Thanks for the very kind words of introduction. It's a pleasure to be here, and I want to express my appreciation to the Lieutenant Governor for her inspiring remarks, which will help frame my own remarks this morning, and as well to the Canadian Race Relations Foundation for offering me the opportunity to share some perspectives with you today. Indeed, I'm delighted to participate in what I take to be the common cause that brings us together. In a word, towards a plural, inclusive, egalitarian Canada in 2017 and beyond. Respectful of diversity, of the dignity of difference, which, interestingly enough, was a subject, it's not that well known, of both the Prime Minister's talk and that of the Foreign Minister Stéphane Dion at the UN General Assembly on a panel there on diversity and inclusivity. And let me quote from the concluding remarks of Foreign Minister Dion on that occasion. Quote, "Diversity is a fact. Inclusion is a choice. Choose inclusion and declare to the world that diversity is strength," unquote. Such that the notion of an inclusive Canada was held out by both the Prime Minister and Foreign Minister Dion just a month ago at the UN General Assembly, not only as a domestic principle and priority, but a foreign policy one as well. And so what I propose to do today is to speak about constitutionalism, in particular Canada's constitutional revolution, as a looking glass, an instrument for the building of an inclusive Canada, one anchored in the pursuit of justice, both Canadian and international. And to borrow a metaphor from the Lieutenant Governor, as the lens through which we work towards building an inclusive Canada. As it happens, we meet at an important moment of remembrance and reminder. We meet on the eve of the 35th anniversary of the Canadian Charter of Rights and Freedoms, a revolutionary act which had a transformative effect not only on our laws, but on our lives, not only on how we litigate, but on how we live. And where former Chief Justice Antonio Lemaire, speaking on the 10th anniversary of the Charter of Rights and Freedoms, compared it to the discovery of Pasteur in science. Admittedly, enthusiastic rhetoric by the Chief Justice, but nonetheless reflective and representative of this constitutional revolution. We meet as well on the 80th anniversary of the Nuremberg race laws, which became prologue and precursor to the Holocaust and mass atrocities, and the 150th anniversary of Confederation, a historic milestone as backdrop for this conference and for my remarks. Accordingly, what I would like to do with this in mind is, number one, share with you a brief snapshot of pre-charter life and law, which is a narrative, regrettably, of discrimination and exclusion. Second, a looking glass at the revolution wrought by the Charter, a revolution in 5 acts. And finally, conclude with some revolutionary principles, or principles for a revolutionary international justice approach anchored in a never again declaration that was adopted unanimously this past spring, and I hope to share these principles with you. In a word, at a time that never again has become yet again, again and again, we need some principles in which we can anchor an approach to the pursuit of international justice as we pursue domestic justice for an inclusive Canada and indeed an inclusive world. Let me begin with a snapshot of pre-charter law and life, which, as I said, is a disturbing narrative of discrimination against, marginalization of, and exclusion of vulnerable groups, including, in particular, discrimination against Aboriginal people, and the Lieutenant Governor focused effectively and appropriately on this issue, against racial and religious minorities, against women, against the disabled, against gays and lesbians, and the like. Moreover, and this is sometimes ignored, this disturbing narrative of discrimination often found expression in institutionalized, indeed legalized, discrimination against vulnerable groups, so that these groups became historically disadvantaged groups. Discrimination, as I have written elsewhere, was often state-sanctioned and institutionalized as law here in Canada. Accordingly, if one looks at it from a juridical perspective, what one finds is that along with, and maybe because of, this social history of discrimination, there was this juridical history of exclusion, the utter absence of a constitutional right to equality, of a constitutional protection against discrimination, and the absence of constitutional remedies to address and redress this inequality. Indeed, as we approach the 150th anniversary of Confederation, any inquiry into the first 115 years of our constitutional history, from 1867 to 1982, would reveal a preoccupation with the powers of government as distinct from the rights of people, with a preoccupation of the distribution of powers between the federal and provincial governments, sometimes known as legal federalism, as against limitations on the exercise of power, whether federal or provincial, otherwise known as civil liberties. Professor Bourlaskin, who went on to become the Chief Justice of the Supreme Court of Canada, summed up this constitutional experience of our first 115 years in one pithy sentence, and I quote, "The basic constitutional question," he wrote, "was which jurisdiction has the power to work the injustice, not whether the injustice itself should be prohibited." Or as he commented in another context, "The constitutional issue is simply whether the particular suppression is competent to the Dominion or the provinces, as the case may be." In summary then, while there were admittedly certain protections under the common law, protections under the rule of law, statutory protections for civil liberties, anti-discrimination statutes, and the like, there were no entrenched constitutional rights. There was no constitutional role for the courts to protect rights. There was no constitutional anchorage for a process of judicial review. There were no constitutional remedies, and there was no basis for a process of judicial review to invalidate legislation on rights grounds rather than on jurisdictional grounds. And then came the transformative impact of the Charter. And here what I would like to do is discuss this revolutionary impact as a revolution in 5 acts. The first act was the adoption of the Constitution Act, whose centerpiece was the Canadian Charter of Rights and Freedoms. The very adoption of the legislation moved us from a parliamentary democracy to a constitutional democracy, from the sovereignty of Parliament to the sovereignty of the Constitution, from the courts being the arbiters of legal federalism, which they continued to being the guarantors of human rights, not because the courts sought that power, let alone usurped that power, but because Parliament, in the Constitution Act, through the Canadian Charter of Rights and Freedoms, vested that power in them. And individuals and groups in Canada who had been passive objects of the vicissitudes of legal federalism now became rights claimants, rights holders, with a panoply of rights and remedies that was hitherto unprecedented in terms of pre-charter law, a panoply of rights and remedies to move us forward for that inclusive society. Which brings me to the second Revolutionary Act. And the second Revolutionary Act was one brought about by Canadian civil society, of the Charter as being itself the product of an inclusive revolutionary act. In other words, the Charter of Rights and Freedoms that we now have is not, as it is sometimes held out to be, the Trudeau Charter, or the Charter as proposed by the Trudeau government, though, and to his credit, he did initiate the process of a Charter of Rights and Freedoms. But the Charter that we now have was one brought about by civil society in this country, particularly in the year of the Constitution in 1981, where hundreds of individuals and civil society groups came before a joint House-Senate Committee on the Constitution to propose their amendments to the Charter. And as a result of this civil society set of representations, we now have what can best be called a People's Charter. And time does not permit me to go into it, but I can tell you almost every section of the Charter of Rights and Freedoms that we now have is one brought about by an inclusive set of representations by civil society, including Section 1, which gave us the threshold for a free and democratic constitutional democracy, the broad protections of fundamental freedoms in Section 2, the equality rights protection in Section 15, an excellent case study, if you will, of the manner in which civil society, and particularly women's groups, transformed this section. Because the initial draft of the Charter, the Trudeau draft, spoke of equality before the law. But women's groups knew that those words were insufficient and did not protect Canadians as they were then included in the Canadian Bill of Rights and the like. And so they brought forth amendments so that Section 15 read as equality before the law and under the law, an equal protection of the laws and equal treatment under the laws, and the prohibition against discrimination on 12 grounds and other analogous grounds. And the women themselves also appreciated that perhaps even this might not be enough. And so as a result of their advocacy, we have also Section 28 of the Charter. You know, you sometimes hear about the notwithstanding clause, but what you don't hear about is Section 28, which begins with the words that notwithstanding anything in this act, men and women are equal in all respects. An egalitarian, constitutionally entrenched provision brought about by women's groups. And you have also in Section 27, almost the only charter of rights in the world which constitutionalizes multiculturalism, which first found expression in public policy in the 1971 Multicultural Act, but which was now constitutionalized in the Charter of Rights and Freedoms. And you have also an international law provision that was not there, and that is Section 11C, which constitutionalized the prosecution of war criminals, where it said that retroactivity shall not avail as a defense against prosecution where the crimes are criminal according to international law or according to the general principles of law recognized by the community of nations. And rounding it all out, Section 24 and 52, which introduce the constitutional remedies protection and the supremacy of the Constitution. All of which brings me to the third Revolutionary Act. And the third Revolutionary Act is the impact of the global human rights movement at the time on the text, interpretation, and application of the Charter of Rights and Freedoms. As Father Robert Drinan wrote in his book on the history and hopes of the human rights revolution in the late 70s and on the eve of the Charter, that the elevation of human rights into an international juridical norm was the most dramatic development in the history of contemporary jurisprudence. And that international human rights revolution, which was unfolding at the time, also impacted on the Charter of Rights and Freedoms, and indeed was so recognized by former Chief Justice Brian Dixon, who in the Public Service Employees Relations Act some 35 years ago said that the various sources of international human rights law, declarations, covenants, conventions, judicial and quasi-judicial decisions of international tribunals, customary norms must, as he put it, must, in my opinion, be relevant and persuasive sources for the interpretation of the Charter. And if you want to understand the dramatic impact of this third revolutionary act, it can be found in the fact that under pre-charter law, there was only one case that made reference to international law, or in general international human rights law in particular, the Drummond-Wren case, which dealt with the unconstitutionality of an anti-discrimination provision, but which was reversed on appeal. But since that, and in post-charter international jurisprudence, there have been hundreds, even thousands of cases that in fact invoked and implemented international human rights law as a relevant and persuasive source, as Chief Justice Dixon opined, for the interpretation and application of the Charter. Which brings me to the fourth Revolutionary Act. And that one is the constitutional revolution that was wrought by revolutionary constitutional jurisprudence, by a series of landmark decisions that constituted a critical mass of rights litigation that has literally transformed constitutionalism in Canada. Let me quickly summarize this. The first important and indeed historical case, it is not that well known, but had a real impact on the Charter. I was reminded of it, in fact, by the words of the Lieutenant Governor, because it speaks to the constitutional responsibility of the Crown. Because what is not that well known is that, again, the Trudeau Charter did not apply the Charter of Rights and Freedoms to the executive branch of government. It was applicable only to acts of Parliament, federal or provincial. It was this first case known officially as Operation Dismantle and the Queen, a case in which a coalition, again, a coalition of civil society groups, reflective and representative of the notion of an inclusive Canada, Aboriginal groups, peace groups, women's groups, environmental groups, came together to seek to enjoin the flight testing of the cruise missile. At the time, Associate Deputy Minister of Justice Ian Binney went on to become a Justice of the Supreme Court of Canada, was acting for the government in seeking to reject, and let me make full disclosure, I was acting as one of the lawyers for Operation Dismantle at the time. But Ian Binney, who was a close colleague and friend, we'd worked together initially on the McGill Daily, and he addressed our constitutional application as one that was frivolous, vexation, and an abusive process, and should be dismissed immediately. Well, fortunately, we managed to secure a victory on the merits in the court of first instance, someone said, because we had a rather eccentric judge hearing the case. It was reversed on appeal, and that reversal was affirmed unanimously by the Supreme Court of Canada. That was on the merits that one could not enjoin the testing of the cruise missile. But the court handed down an extremely important judgment in which it held, because the government had argued that otherwise that the Charter of Rights did not apply to the executive branch of government. And the court held in that regard, the Supreme Court, that it did indeed apply to the executive branch of government, and also to the excise or the royal prerogative, and even maybe in an obiter dictum in matters of foreign policy. So you had an historic judgment in 1983 in Operation Dismantle, which resulted in the Charter applying to the executive powers of government. There were other important decisions in the areas of freedom of religion, where the court held unconstitutional any notion of an established religion or any notion of established religious prayer in the schools and the like. In other words, poured content into the notion and principle of freedom of religion. You also had important and dramatic jurisprudence in the area of freedom of expression and hate speech jurisprudence. And here I want to make particular mention of a trilogy of cases in that were first argued in 1989, decided in 1990 by the Supreme Court of Canada, which, while affirming freedom of expression as being a compelling and fundamental right, as being really a core right that in pre-charter law was expressed in the Switzerland and Evelyn case as being liberty in these matters is little less vital to man than breathing is to his physical existence, while at the same time affirming freedom of expression as, to use the words of the courts, as the lifeblood of democracy, nonetheless held that freedom of expression is not an absolute right. And I want to just state parenthetically that whereas the notion of the First Amendment doctrine in the U.S. is sometimes held out to be an absolute right, it is not the case. Even under the First Amendment doctrine, you cannot commit perjury. Perjury is not protected speech. False and misleading advertising is not protected speech. Treason is not protected speech. Fighting words is not protected speech. And in Canada, in our jurisprudence, you have the important decisions made in which it was held that while freedom of expression is the lifeblood of democracy, nonetheless, assault of hate speech constitutes an assault on the inherent dignity of the human person, on the equal dignity of all persons, on the right of minorities to protection against group vilifying speech, an assault on our international treaty obligations to exclude racist hate speech from the ambit of protected speech and the like, all of which found expression as well in the National Justice Initiative on Racism and Hate, which I initiated as Minister of Justice, and of course in the great work that has been done by the Saskatchewan Human Rights Commission under its exemplary leadership of its chair. And you heard about this in yesterday's deliberations, and I regret only that I was not here at the time. But Saskatchewan is an example, really, of citizen advocacy, of citizen education, of the hallmarks of an inclusive Canada in the best sense of the word. And let me close about the revolution wrought by this constitutional jurisprudence by referencing the area of equality rights, because this is perhaps the most significant part of the constitutional jurisprudence. The egalitarian rights and remedies that were affirmed and implemented for women, for minorities, for the disabled, and in particular for Aboriginal people. Which brings me now to the final and the fifth Revolutionary Act, and I was reminded of this by the Lieutenant Governor's remarks. And I'm speaking here about not only constitutional rights, but constitutional responsibilities of government. The constitutional responsibilities that were brought about by the Charter of Rights and Freedoms through, in particular, the role and responsibility of the Minister of Justice and Attorney General of Canada acting on behalf of the Crown of the Government of Canada. And let me just give you some of those responsibilities, and with this I conclude the Fifth Revolutionary Act. The responsibility of the Minister of Justice to certify that every prospective law and policy comports with the Charter. Regrettably, a constitutional responsibility that has been honored more in the breach than in the observance. and I introduced a private members bill to put that into effect, and there's now a campaign by the Canadian Civil Liberties Association and others in order to implement that in our constitutional and evolving law for an inclusive society. But this is something that must underpin the principle and practice of an inclusive Canada. As well, the minister must counsel every agency and department of government with the principle of fidelity to the Charter, of a culture of respect for the promotion and protection of the Charter of Rights and Freedoms, including respect for the independence and integrity of the judiciary. Third, in matters of interventions before the courts, it is the responsibility of the government, again through the Minister of Justice, to ensure that government interventions comport with the Charter. And the minister here can influence the promotion and protection of rights by determining whether, when, and how to intervene in constitutional cases. A fourth is the important role of the government, through the minister again, with respect to our international law obligations, of ensuring as well that Canadian constitutional law advocacy comports also with our international law obligations as set forth in the governing principle of Chief Justice Dixon. Number 5, the minister has a particular role with respect to the criminal justice process in ensuring, for example, that prosecutions are carried out in accordance with the Charter, such as the obligation of disclosure to the defense, or in militating against solitary confinement, a matter that is now before us, has been exposed in Ontario, but it is a widespread phenomenon in Canada, where we must address and redress this phenomenon of solitary confinement, which very often breaches the threshold requirements of protection in international law against torture, against cruel and unusual punishment, and against equality before the law, and which differentially impacts on the most vulnerable in our society, such as Aboriginal peoples. 6, the minister has a unique role of ensuring that applications for wrongful conviction are heard and has the authority to determine that there is a reasonable basis to conclude that a miscarriage of justice has occurred, and thereby seek to remedy the situation, as I had occasion to do as minister in the Truscott case. An interesting case for me, because I studied the Truscott case as a law student in the early 60s, but as a capital punishment case, not as a wrongful conviction case. When it came before me 40 years later, it was as a wrongful conviction case, and finally Truscott got the remedy that he deserved and the acquittal that was warranted. The 8th is the special role and responsibility of the minister in matters of Aboriginal justice. And I just want to single out former Prime Minister Paul Martin here, because in the first cabinet meeting that we had, he said that the question of Aboriginal rights, of our relationship, people-to-people relationships with the Aboriginal peoples, will be our legacy issue. As he put it then, there are no votes in this, but at the end of the day, we will be judged by our relationships with the Aboriginal peoples. And it was through that and the responsibility I had as Minister of Justice that we developed the 7 R's of Aboriginal justice, which included recognition of the Aboriginal people as Indigenous peoples now, as the First Nations, the original inhabitants of our country. Respect for their distinguishable constitutional status and rights. 3rd are redress for past wrongs, including the legacy of the residential schools. 4th are countering the over-representation of Aboriginal people in our prisons and the under-representation of Aboriginal people as judges, law enforcement officers, and the like. The 5th R was that of responsiveness that the Crown had to be responsive to Aboriginal rights and treaty relationships, resource developments, and the like. The sixth R was the whole process of reconciliation. We have the recommendations now of the Truth and Reconciliation Commission. And the final R was that if we did the first 6 Rs, then this would lead to the final R, which would be a renewal of our nation-to-nation relationship with the Aboriginal people. And finally, let me go to the last theme that I wanted to discuss, and that is moving from domestic justice to international justice, all part of an inclusive justice, domestic and international, and the particular role that Canada can play. And share with you, almost in the way of one-liners for reasons of time, some of the foundational principles that were adopted by a Never Again declaration on the occasion of an international legal conference we had in May at Jagiellonian University in Poland, as I said, on the occasion of the 80th anniversary of the Nuremberg race laws, also the 70th anniversary of the Nuremberg trials, in a conference on the theme of the double entendre, the double meaning of Nuremberg, the Nuremberg of hate and the Nuremberg of judgments. And let me now summarize the Never Again declaration, unanimously adopted by former ministers of justice, judges, scholars, representatives of civil society, and the like. The first was the danger of forgetting and the importance, indeed imperative, of remembrance. And indeed, Lieutenant Governor spoke about the importance of the lessons of the past in terms of directions for the future. And here the incorporation of this principle was a notion of the remembrance of the Holocaust and mass atrocity, not as a matter of mass or abstract statistics, but that unto each victim there is a name. Each person is an identity. Each person is a universe. Recalling also the Talmudic idiom that if you save a single life, it is as if you have saved an entire universe. And so the first abiding principle, and really an abiding principle for an inclusive Canada, that we are each, wherever we are, the guarantors of each other's destiny. The second principle was the danger of silence in the face of evil, of the responsibility to speak and act against injustice. That wherever evil is to be found, we must speak and act even if we fail. As the former great Soviet dissident Andrei Sakharov said to me, I do not know what will help the cause of human rights. I do know that it will not be helped by silence in the face of evil. The third is the danger of state-sanctioned incitement to hate and genocide, the responsibility to prevent. The Holocaust and the genocides that followed occurred not simply because of the industry of death, but because of state-sanctioned cultures of hate. It is this teaching of contempt, this demonizing of the other, this is where it all begins. As the Supreme Court of Canada put it, that the Holocaust did not begin in the gas chambers. It began with words. These, as the court put it, are the chilling facts of history. These, as the court put it, are the catastrophic effects of racism. And that holds true in democratic societies as it does in state-sanctioned cultures of hate. The fourth is the dangers of indifference and inaction in the face of mass atrocity. Let us be very clear about this. What makes the Holocaust, the genocide in Rwanda and Darfur, the mass killings in Syria, what makes all this so unspeakable is not only the horror of the genocide and the mass atrocities themselves. What makes them unspeakable is nobody can say we did not know. We knew, but we did not act. Just as today, as the mass atrocities take place in Syria, nobody can say that we did not know. At the end of the first year, where there were, quote unquote, only 7,000 dead and 50,000 displaced, as we meet, there are now over 500,000 killed, 12 million displaced, over 5 million refugees. Nobody could say we did not know. Those of us at the time who argued on behalf of the international principle of the responsibility to protect and to intervene to protect the targeted Syrian civilians were told, you know, if you intervene, this will lead to sectarian warfare, this will lead to civil war, this will lead to jihadists coming in. Everything we were told that would happen if we intervened happened because we didn't intervene and give effect to the R2P doctrine. And so the importance, therefore, of the responsibility to prevent. The fifth is the danger of impunity, the responsibility to, in fact, combat the cultures of impunity, to bring war criminals to justice, lest we embolden and encourage new war crimes and new war criminals. And I regret to say that we are on the eve, in terms of a culture of impunity, of the election or re-election of major human rights violators, Russia, China, Saudi Arabia, to the UN Human Rights Council, which will take place tomorrow as a foregone conclusion. In other words, the UN Human Rights Council, which is obligated by charter and by mission to promote and protect human rights, will be electing major human rights violators to the UN Human Rights Council, expressive not of a culture of human rights, but of a culture of impunity. The sixth is the danger of la trahison d'éclair, the betrayal of the elites, and the responsibility to speak truth to power. In a word, Nuremberg crimes were the crimes of the Nuremberg elites. The seventh is the danger of assaults on the vulnerable, that the test of a just society, the test of a just and inclusive society, is how does it treat its most vulnerable? How do we treat our elderly, our sick, our violated women, our immigrants, our refugees, our Aboriginal people, our battered children? The most important lesson I was ever taught about this, and I repeat it on every occasion that I can, was that taught to me by my daughter when she was 15, now 37 years of age, when she said to me, Daddy, if you want to know what the real test of human rights is, always ask yourself, at any time, in any situation, in any part of the world, is it good for children? Is what is happening good for children? And may I close with two other principles. One is the importance of standing with political prisoners. Because if you want to understand the transformative impact of freeing political prisoners, let us never forget that one person, Nelson Mandela, who endured 27 years in a South African prison, emerged to not only preside over the dismantling of apartheid, but to become the president of the first ever democratic, free, egalitarian South Africa. And so the importance, therefore, of working to free political prisoners. And I bring up now the case of one on whose behalf I am acting, namely Raif Badawi, the imprisoned Saudi blogger, whose freedom of expression ended up being criminalized with imprisonment and torture in detention, and whose family are refugees in Quebec and deserve to be reunited with him as he and they wish. And finally, the danger of being bystanders to evil. The inspiration of a Raoul Wallenberg, who showed how one person with the compassion to care and the courage to act can confront evil, can resist, and thereby transform history. Just one datum. In 1944, from May to July, 440,000 Hungarian Jews were deported to the death camps in Auschwitz. Wallenberg arrived in July 1944, and this Swedish non-Jew saved the remnant of 100,000 Jews in the ensuing months until he regrettably disappeared into the Soviet gulag, himself became, in effect, a political prisoner. But if you say, when I mention these things, well, you know, I can't be a Raoul Wallenberg or a Nelson Mandela or an Andrei Sakharov, let me just close with the words of the great sage Maimonides, who teaches us how each one of us can play a transformative role in the building of an inclusive Canada, in the building of an international justice system, where Maimonides tells us that we should each see the world as being divided into half evil and half good. Therefore, one good deed by any one of us on any given day can transform the cosmic scale of evil to good. That is where we each have not only, I would say, a responsibility, but a privilege to partake in the historic role of building an inclusive justice system domestically and internationally. Thank you.